If you haven't seen the play, you should come. They wear costumes in the play. All right, so here we go. In addition to having Right Honourable Beverley McLachlin with us presiding over today, we also have Justices Ian Binney, Earl Cherniak, Patricia Jackson, and Mayo Moran. And these are both lawyers, judges, and also from the academic community. And we have the counselor for the appellant is, and the appellant in this case is Shylock, of course, is Shylock, and Alan Lenzner is the counsel for the state. And of course, in this situation, it's somewhere between Stratford, Canadian laws, and the Serene Republic. Would we all please rise for the court? Thank you, yes. Oh, the suspense. They're not there? Hello? Well, it's nice to see you all. This is Shylock, who is speaking for the appellant, and Alan Lenzner. And to the right of the Chief Justice is Justice Ian Binney, and then Patricia Jackson, and Earl Cherniak is to her left, and I have that correct, right? And Dean Mayo Moran is to Mr. Cherniak's left. All right.
May it please the court, Chief Justice, Justices, this case is about injustice at the hands of the justice system. The appellate court has the responsibility, indeed the burden, to right the wrongs. I have 3 points. There are 3 errors. First, the penalties are inflicted without notice. Secondly, the penalties contravene the charter, which is the supreme law here. And third, the essential terms of the bond were enforceable and were settled by the parties. The imposter, Portia, wrongfully interfered with that settlement. Now, before getting to the legal errors, let me give you some background to Shylock's behavior. The actors have picked up the story toward the end, but I need to introduce my client to you. He is not the merchant of Venice. Indeed, he could not be. He could not hold land. He could not belong to a guild of artisans or professionals. Indeed, the only thing he was permitted to do was to lend money, for which he was abused by Antonio, the respondent. Indeed, that abuse would be bad enough, but he was abused and dealt with unjustly for another reason. He is a member of the chosen people, a Jew, the very people God chose to bear his beloved son, also a Jew. In my copy of The Merchant from high school, the explanatory notes tell us says here, the fact remains Antonio treated Shylock unjustly. Now that's a measure of description for blatant abuse and hateful derision that Antonio heaped upon Shylock in the Rialto, in front of the citizens of Venice. Antonio berated him, called him misbeliever, cutthroat dog. He spat on his cloak, spat in his face, kicked him like a cur, disgraced and scorned him. And then uses him. I think there's a jury. I was told to turn around when possible. And then he uses him for money to lend himself to Bassanio, for Antonio to play the loyal, the beloved, the generous, the benevolent friend. announcing all the while that although he needs Shylock's assistance and money, he would happily spit on him again and spurn him. Yes, Antonio is definitely a man of principle. Beyond that, Antonio entices him away to a dinner on the very night that Jessica, his beloved daughter, is stolen away by Lorenzo. All this to say that
I concede that this case engages serious charter issues if it's properly before us, and that this court has quite a large jurisdiction to extend the time within which to seek an appeal. But 400 years?
well, my client would be here to explain, but he's apparently getting ready to leave a shtetl in Russia shortly. But the courts must decide individual cases. I appreciate that. But for courts to have respect of the populace, they must stand for justice and stand against injustice. So whether it's Hurricane Carter or Trayvon Martin, whether it's Stephen Truscott or Donald Marshall or Dreyfus or Dred Scott, the wrongs, these injustices, stain the system of justice, and it is capable, as was the case with the merchant, capable of being misused. The merchant is still among us. It was misused in Nazi times. Shakespeare was the only enemy writer that was allowed to be played, and they played Shylock 50 times between 1934 and 1939.
Counsel, is it not the height of judicial activism to revise a deed made more than 400 years ago in the name of the law made some 30 years ago?
Well, the deed, indeed, the deed that is made at the end of this play it needs to be rectified. Because on my third point, I will show you that there was a deal, a settlement, for the amount of the principal that Portia, the imposter, interfered with. But let me get to my first.
Well, Counsel, on that point, are you asking for the return of the 3,000 ducats with compound interest for 400 years? Have you considered the effect on the already parlous Italian economy?
My client, right from the beginning, said he would do this without interest. So your compound interest point is irrelevant. In any event, on my, with all due respect, I'd like to say that. So all of this to say is that Shylock was entirely justified in his hatred of Antonio. And Antonio, for all the love he engendered for all his friends, or perhaps purchased from those hapless and wastrels, was a man who dehumanized another for the sport of it. That he was affable and beloved by many is irrelevant. It's like saying Hitler loved babies and dogs. His true character, Antonio's that is measured by his treatment of Shylock. Treatment that drove my client to seek good old-fashioned, Old Testament revenge. Shylock, the Jew, was a man, a human, one of God's precious creatures, and as Shylock said, hath not a Jew eyes, hands, organs? If you prick us, do we not bleed? If you tickle us, do we not laugh? If poisoned, does he not die? And if you wrong us, shall we not revenge? The villainy you teach me, I will execute. And that takes us to the bond, which is the centerpiece of this case, freely entered into by Antonio.
As a merry bond, not as a serious debt.
Well, things happened afterwards. Jessica was stolen away by Lorenzo, conspired by Antonio
At the time of the bond, Shylock himself said, what use would I have of a pound of a human flesh? I'd rather have mutton or beef.
He changed his mind.
Well, yes, he did change his mind. That's what the abuse of the system in order to wreak revenge is not really what a court of law is supposed to be about.
Well, we have to get to the end of the court of law. And when I get to point 3, I'm going to have you all, I know it. This bond was accepted. It was lawful in its terms. Antonio wrote, my bond is forfeit to the Jew. I've given you at tab 1 of the brief the references where the Duke's, where he said the Duke cannot deny the course of law. Portia, when she questions Antonio, do you confess the bond? I do. And then said, well, the Jew must be merciful. She accepted that the bond was legal and enforceable, indeed immediately gave us a lecture on the quality of mercy. Because as she said, this strict court of Venice must needs give sentence against the merchant.
But surely, counsel, since we are now governed by the charter, this bond seems to contravene public policy and the dignity of the human spirit.
I agree with that. I agree with that, Dean Moran. Dr. Moran, it does contravene the charter, and it is now recognized as not being enforceable in that term. That's contrary to public policy. But the essence of the bond is enforceable, and I'll come to that in my third point. And clearly, this third point is going to be so... Clearly, Shylock had no hint, let alone any notice, that the bond was not enforceable, as he says. And you'll see this at the last page of tab 1. What judgment shall I dread, doing no wrong? So Antonio, the Duke, Portia, Shylock, all believed the bond enforceable. And that leads to my first point. The penalties that were inflicted on Shylock were illegal. They were entirely without notice. You look like you're going to ask me something, Chief. Okay, good. I'm always relieved when the Chief doesn't ask me anything. He knew that not that there was any case he had to meet, let alone the case he had to meet. Indeed, the only purpose of the hearing was to enforce the bond that everyone said was valid and due. And a person must know the case he has to meet. And here there was no notice to Shylock that he was the defendant, that he was the accused, that he was in peril of losing his life, losing his religion, losing all his property, that he could become a slave to Christianity. And all of these are illegal punishments, which is point number 2. Keep your eye on point number 2. But even if any of these were legal punishments, it is fundamentally wrong to impose them without notice.
But isn't the beauty of the law the fact that every man is deemed to know the law? And so no one needs notice of the law.
No one knew this law. Everyone accepted, and this is important because it shows that this part is severable. Everybody accepted that the bond, in its terms, was enforceable. So no one knew this. We are now better informed. 400 years have gone by. We have higher sensitivity. But I
don't think it was accepted at the time that the whole bond was enforceable. The principle was enforceable. But whether or not the penalty imposed for failure to pay the bond is very much an issue.
It was not an issue in the Duke's mind.
It was the merry bond. It wasn't taken seriously. That's what Shylock told Antonio. So Shylock is the one who switched the rules in the middle of the game and now took it seriously because his daughter ran off with somebody that's irrelevant to the whole plot.
Right. Well, this doesn't... I agree. I find that whole subplot completely annoying. But this really doesn't matter for point number 3. So I'm going to be getting the hook in 2 minutes. So let me just pass on. And even if you're right, he had no notice that he was at risk. And indeed, as we know under our law, the Crown must give disclosure. There's no indictment, there's no particulars, there's no disclosure, no hint of any penalty. And at tab 2, I've given you the Sharkawi case and excerpts from your powerful and eloquent decision, Chief Justice, in that case, which are... and Justice Finney, I looked for powerful and eloquent judgments by you, but time did not permit. So you will see the affected person, in this case Shylock, has to be informed of the case he has to meet and has to have the
You're saying the chief is a Daniel of the judge? Is that your point?
Dare to be a Daniel. That's what my mother always said when I named my son, my beloved son, who's in the audience, Daniel. Second point, nature of the penalties are unlawfully inflicted. First of all, death penalty, not on even a government that likes to build lots and lots of prisons, cannot reopen that debate. Over. But Portia, claiming that Shylock's life can be taken, totally wrong, and then the Duke and Antonio trading it off for various other conditions, lest the death penalty be restored, completely improper. So after Antonio and the Duke make all their conditions, the Duke saying, "He shall do this, else I recant my pardon," after they do that, then the legal impostor Portia demurely asks, and Our friends at Stratford have changed one word in this play. I have it from high school. She says, "Art thou contented, Jew?" She changed it to Shylock, and it sounds a little better. But "Art thou contented, Jew?" I am content. Well, that's duress. That's undue influence. That's extortion. State-sponsored. It cannot stand.
That's waiver.
Waiver.
Agreement.
Waiver when they say, "We're going to kill you unless you say yes."
An agreement that has stood for 400 years unchallenged.
You know what's very good about this is that he's retired from the Supreme Court and the Chief Justice is still there and she does not think it's waiver. All right. Well, we don't get to hear the third point, do we?
Chief Justice, my ladies, my lords. Firstly, I want to point out the wisdom of my client, the Duke. He's put 3 members from the female gender on this court. And there are only 2 male members, but I must say in their favor, they were chosen on merit. My friends,
Mr. Lenzner, is that your best point?
Is that unlike the other members of the court?
No, I said in addition. In addition. Now, this is not a commission of general inquiry. And I want to just give a little bit of the background because it frames the legal arguments. Venice in the 1590s was the center of global commerce, the world's meeting place, the intersection of Eastern and Western cultures. Ships from many countries teem in its ports. Merchants from all over Europe are trading their manufactured goods with Moors, Turks, Tartars, and Chinese, who are offloading raw materials and agricultural products. Every language is spoken in the city. As a republic, though, Venice is governed by its chief magistrate, the Duke, who administers its laws and social mores. Venice displays an unparalleled degree of religious tolerance, permits Catholics, Protestants, Jews, Muslims, Buddhists the right to build their own places of worship and to express their faith without restriction, openly and freely.
Are we going to come to this facts of this case at some point in your submissions?
Right now, Mr. Justice Binney, overriding this tolerance, and this is the important point, and to avoid the type of religious persecution that we have seen in democracies such as France when they persecuted the Huguenots, in Spain with the Inquisition, in Ireland with the Catholics against the Protestants, and in Persia, Sunni versus Shia. Overriding the freedom of religion is the rule of law, which represents the appropriate limit and the boundaries which no person can transgress. Let me deal with my friend's first point, the lack of notice. I have 3 points to make on this submission. Firstly, Venice, unlike Canada, which is in a fledgling state, has a fully integrated system of civil, criminal, and administrative law. It does not pigeonhole a case as being criminal or civil and thus apply only that body of law. Venice espouses the one body of law concept. Even in Canada, now 400 years later, we have a fledgling elements of such a concept. The Proceeds of Crime Act, for example, allows a criminal judge not only to impose a custodial sentence, but also to require restitution to the victims. Securities commissions, with similar acts all across the country, sanction respondents by excluding them from capital markets, but also order disgorgement and administrative penalties. So you have
it's already been tried to combine executive, legislative, judicial, civil, administrative, and it's called the French Revolution. A bit of terror
Well, I say that where Venice is way ahead of Canada is that it takes elements from all of these aspects of the law and needs them together. And this is what happened in this case.
Mr. Lenzner, are you saying that the imposition of the death penalty and the use of that as a threat to extort wealth is a positive development in the law that Canada should be adopting?
It wasn't the imposition of the death penalty that was used to extort the money. The death penalty was a reaction to what Shylock was proposing to do.
Do you stand behind the imposition of the death penalty?
The death penalty is imposed all over the world, in the United States and many other countries. Venice has chosen to impose the death penalty when, as the court said, the judge said below, you threaten the life of someone, of a Venetian resident, then you stand in jeopardy of losing your life. And I see nothing unfair about that.
If the state itself is imposing the threat to the life of the Venetian resident, is that not inconsistent with the principle you just espoused?
The state isn't imposing it, that's the law. The law is that if you threaten someone's life, you have a penalty that you have to pay. Venice has chosen the penalty of death.
It's not the law that the penalty is only imposed on a racially exclusive basis.
No, it isn't imposed on a racially exclusive basis. And let me just then take you to the elephant in the room.
Can I just ask you this first, Counsel? Let's get down to the facts in this case. Does the law of Venice allow a judge, an imposter and a conflicted judge at that, to descend into the arena and lead Shylock the way that this judge did?
Well, you've got a number of questions there. Let me take them one at a time. But that's typical of getting a convoluted question. First of all,
Loaded.
The judge didn't lead the Shylock into any misunderstanding, because what she did say, she started off by saying, she ruling in Shylock's favor. She said, "A pound of that same merchant's flesh is thine. The court awards it, and the law doth give it." So she gave him what he wanted. She then notified him that he was not to spill one jot of blood, because it was not express. And there was an implied term in this contract that you could only do what was provided for and nothing more.
But a ridiculous term. Obviously, taking a pound of flesh is going to require taking blood. It was an absurd interpretation of the bond.
It was an absurd bond to make in the first place. As you have said, it was never intended to be that. You've already admonished my friend for turning
I'm after you now.
You do realize that your paycheck is in jeopardy.
Mr. Lenzner, I'm amazed that you haven't addressed the most fundamental aspect and important aspect of any appeal in Canada today, or Venice for that matter, and that is standard of review. I want to know whether we should judge this case by correctness, reasonableness, or patent unreasonability.
He's not qualified to answer.
After 40 years and traipsing up and down between reasonableness and unreasonableness and patent unreasonableness, I think the court should finally land on one point and call it correctness. And let's just deal with that as a standard. And I say, in terms of the facts, which are not in dispute in this case, then you owe deference to the judge below. In terms of the law that the judge below applied.
She wasn't a judge.
That's Justice Cherniak's other point. There is this old boys club, an old girls club here, that only somebody who pays their fees to the law societies becomes a judge. What about common sense? Shylock thought she had common sense. He said, "Oh, wise judge, oh, noble judge, oh, Daniel."
Look, if Bassanio had been required to pay, that money would have come out of Portia's pocket. She was most financially at risk in this whole adventure. And she is the one who purports to pass justice.
Temporarily. He would have made it back in spades and given it back to her in spades.
Well, he
Nothing-
lost his own fortune before he ever got to Antonio.
Well, look. Husband and wife are one unit. You can't separate them out like that.
The holistic approach.
That's right. So let me deal just with what I call the elephant in the room, the charter argument, and whether this is contrary to the charter as we know it today. And I say it is not, for these reasons. First of all, there is no general law preventing Jews from practicing their religion or setting up synagogues or anything of that nature. Secondly, in any event, what happened here is justifiable in a free and democratic society. And Venice was that. The punishment is aimed at Shylock alone. Its objective is behavior modification. And behavior modification is a term we well know we use to allow every kind of class action to proceed. And in this sole instance, behavior modification is justified because why? Shylock was not at all concerned with the outcome of the commercial transaction. And that's what this is, a commercial transaction. He refused 6,000 ducats, 9,000 ducats, even more. He was only concerned with revenge and the death of a competitor. In fact, he says this, I hate him for he is a Christian, but more, for in that low simplicity he lends out money gratis and brings down the rate of usuance here with us in Venice. So that's what he was upset about.
Is vengeance a capital crime?
Well, when you're going to, if the outcome of the vengeance, the result of the vengeance is someone else's death, then yes. The required conversion is not to be seen as an anti-Semitic statement or contrary to the freedom of religion. It signals a deterrent to any merchant who seeks to impose his will unfairly or on a competitor. It reinforces the intent.
What would it do to a Christian who sought to do exactly
Same thing.
Require them to convert to Christianity? In
May
what
well
way is
be.
that
We're not-
behavior modification?
That's not the case we're dealing with here. Why?
In what way is that behavior
I
modification?
am not going to speculate on other facts.
In what way, in this case, is that appropriate behavior modification?
In this case, it is because it actually reinforces the intent of the Competition Act, which strengthens.
Do I have your point, Mr. Lenzner, that making him a Christian reinforces the point of the Competition Act?
This case strengthens proper competition and restricts or eliminates unfair competition.
Do you have another point, Mr. Lenzner?
My last point is that, as the Chief Justice said, the courts are sometimes accused of being overactive, judicial activism. I note in this court, I think there was a lot of judicial interference with counsel's attempts. Thank you, my lords and my ladies.
Well, thank you very much, counsel. We're grateful for the assistance you have given us. I think it is likely that this court will reserve its decision, much to the disappointment, no doubt, of many in the audience. However, I must call this time on my fellow judges for their preliminary comments. Justice Stevens.
Well, thank you, Chief Justice. This debate is really all about, in the commercial context, as Mr. Lenzner said, the Duke cannot deny the course of law. So what you have is this notion that if there is an exception made for Shylock, the reputation of Venice across the world will collapse. And there is this subplot that Antonio is a low-cost competitor because the Jews were allowed to charge interest, the Christians weren't. But the legal point is that a debtor in default always has the right to discharge the bond. The notion that Portia introduces that there is some sort of election that Shylock cannot reverse and accept payment of the principal is somewhat absurd. The reality here is that you are dealing with a member of what was in Venice a despised minority. And the minorities traditionally have sought the protection of the law against the majority. That is their refuge. And so it was quite natural for Shylock to shelter himself in the law. And what we have in the play is that the Christian establishment twisted and manipulated the law to destroy this particular individual. The arrival of Portia is central to the power play. She starts off with this hypocritical address about mercy dropping from heaven. She is then the instrument of the cruelty, giving a very narrow interpretation to the bond that nobody contemplated spilling blood. She could have split off the principal from the penalty. She could have taken notice. Yes, I am.
And these are preliminary observations.
So what is interesting, and what we will have to consider when we withdraw to consider our decision, is that Shakespeare has managed to persuade us to side with the majority against the minority, to crush the Jew. And that really is the dilemma that is posed by the play. Can you sacrifice an individual in the unfair way that was done here in order to uphold the broad commercial reputation of Venice?
I think I'm winning.
Mr. Justice Cherniak.
I've never been called that before. The case of Shylock poses an interesting conundrum. Discriminated against, mocked, vilified, and considered an alien in the land where he provided an important service to the commercial lifeblood of the most important commercial center of the age. He decided to exact a terrible revenge on his principal tormentor. But in his favor, he decided to do so not by force of arms, not in the dead of night, not by the use of a paid assassin, but by resort to the law, to the courts of Venice, knowing how important the security of a contract of a bond was to the reputation of the state of Venice was to the world. Many in the last 400 years think that he was fairly and even justly treated. But the law that Shylock chose to invoke turned on him with a vengeance. We must decide here whether he was justly, if not fairly, treated. So, can the verdict stand? The court was unqualified, hopelessly conflicted on one view, not impartial, racially biased. Indeed, the judge turned out to be an imposter. The civil suit brought to enforce the bond was turned into a criminal prosecution without notice, without affording Shylock the basic right to counsel. So should the verdict be set aside in its entirety and Shylock's property and freedom of religion, practice of religion, be restored? That's the question we have to answer. Was the bargain Shylock exacted to achieve his revenge so offensive to public policy, since carrying it out would involve the murder of a citizen of Venice, of the debtor? Was it illegal? Was it void from its inception? That's what Ms. Block argues. That it was unenforceable on its terms, such that the court should provide no remedy whatsoever. We have to wrestle with that. So while one must have sympathy for, a modicum of sympathy at least, for Shylock as a discriminated against minority outcast driven to the brink, who thought he had a legal right to enforce his lust for revenge, can we give him any relief at all? That's the question for the court.
1-1.
Don't be too certain.
Well, being much less accustomed than most of the people on this bench to be thinking in terms of cases on the basis that my decision will not be overruled, or on the basis that the law doesn't apply, and also conscious of the fact that the conflict of interest issue is in the air, and my natural sympathies lie with my partner Sheila Block's client Shylock, I have decided to revert to my interpretation as on a preliminary basis of the Canadian law. And it does seem to me, as sympathetic as we must be in these circumstances, to giving Shylock an opportunity to have the decision below reviewed, that, and recognizing that this court does have the jurisdiction to extend the period in which an appeal can be brought, it does seem to me to allow an appellant to await the development of a legal regime that is more welcoming to his case on another continent 400 years later is rather excessive in terms of interpretation of that jurisdiction. So my preliminary feeling is that I would decline the appeal on the basis that we don't have the jurisdiction to hear it. But I recognize that my opinion is likely to be changed either in a court above or when we retire. And if I were wrong on that point, I would allow the appeal. It seems to me that what we've heard today is some very persuasive advocacy and eloquence, but it differs from the unbounded eloquence that produced the decision in the case below, which was unbounded, but as far as I could tell, completely untethered to any principle of law or fundamental justice that I've ever heard of. So I would allow the appeal insofar as it concerns the imposition of criminal penalties without notice and the extraction of assets without notice. I wouldn't go so far as to enforce the contract in any way, though. I think Shylock rightly points out that to take the life of a Venetian citizen would be contrary to the Charter, would be contrary to the Charter for the state to do that, and it would be even more contrary to the basic principles of fundamental law to allow that to be done by contract. So my preliminary observation is that the contract in its entirety is void, and I would give Mr. Shylock on that nothing. But these are, of course, preliminary observations, and no doubt I'll hear what I'm really meant to decide shortly.
Justice Moran.
Well, I'm very glad to say, first of all, that it seems to me that this matter is purely academic in nature. But along those lines, I do feel that eloquent and well-researched, though the arguments were, they could perhaps have made a bit more reference to the fact that doubtless generations of academics have toiled away in the best law schools and in the law journals of the country and countries around the world, debating the question of whether or not Shylock's bond could be enforced. And I should say, counsel, that excellent though your research was, I would have liked to see some reference to the Albany Law Journal, which in the 1870s devoted issue after issue to debating the case of Shylock. That being as it may, of course, the question of the relationship between law and equity or justice, which is at the heart of this play, continues to preoccupy not only courts, but also teachers of law and law schools. And as I listen to the debates, I am struck by the fact that Shylock, in a sense, chose his own principles of interpretation of contract. He was given the opportunity by Portia to adopt a more expansive interpretation of the contract when he was asked if he had a doctor at ready so that he would not risk the life of Antonio. And he looked at the contract and he said, "It is not written there." Having made that decision to approach the contract in that way, he is, of course, bound by the decision to continue to approach the contract in that way. And when no drop of blood is found in the contract either, he is caught by the argument that served him well in the first instance. And so I, too, reserve my opinion.
Well, thank you to counsel once again, to all my learned justices. I see that we are likely to divide on this matter. One of the good things about being Chief Justice or presiding a court is that by the time it gets to you, all the relevant and some irrelevant points that pertain to the case have been made, so you're relieved of any duty to consider the merits of the case on your own. The bad news about being Chief Justice or presiding judge is that after it's all over, you've got to go out there and craft a unanimous decision, which will be of some difficulty in this case. This case has, you will permit me a few personal comments. I have been on the one bench or another in various states of this land for many, many years. Therefore, unlike Portia, I'm in the reverse situation. My apparent age would lead you to expect much more of me than I'm able to deliver. That's only my first difficulty, but the real difficulty is that I find myself in is that the performance of the company and counsel's submissions have evoked for the first time in over 30 years of judging a central question which had never occurred to me before. What is a good judge? An upright judge? A learned judge, as Shakespeare puts it. So I shall eschew the merits of the case and share with you some of my preoccupations. Obviously, a judge must be a scholar. Portia is a good judge because she looks at all the precedents and she goes into the law. And furthermore, she comes from Padua. Good judges come from far away, I assert. Pincher Creek will do. Thank you. Not only must the judge be a scholar, however, she must be innovative. It's wonderful to watch as Portia goes through this trial, sort of making it up as she goes along. I've had judges like that. Yes. I'm only now realizing that this is quite a common thing in judges, looking at the matter through my new lenses. Finally, a judge, I think, must be wise, and I leave it to you in the audience, and we will wrestle with this later, whether the trial judge in this case, Madame Portia, was indeed wise. But then that leads to other questions. What is wisdom? And these questions, of course, are at the heart of the play. And the play really does address some of the tensions inherent in the art of judging. The letter of the law, is that what judges should do? Or should they be more flexible? The rule of the law, or discretion. The tensions that underlie your respective and learned presentations, I think, force us to confront some of the debates that Shakespeare raised and that are still going on today. Do judges simply apply the rules? Can they simply apply the rules or the contract terms? Or does judging inevitably involve creative, adaptive thinking? Do we hew to originalism, judicial conservatism? Can we? Or on the other side, what about the challenges made in our own time that judges are sometimes too activist? What is the role of judicial discretion versus mandatory minimum sentences? These are questions Shakespeare raised in these cases and in this play, and questions which I think still confront us. So I find myself totally bewildered. I'm sorry to be so unhelpful, but I am certain that when we get in that back room, we will sort it out. You may have confidence in this court. Thank you.
I think you should cite Mr. Lacey for his brown shoes.
one more thing. This is not my point, it's one of my colleagues' points, but it's been brought to my attention that one of learned counsel is wearing brown shoes with blue and black socks. Court stands adjourned.
Innovative thinking, evolution.
Ladies and gentlemen, you can see the greatest court in this land is in very good hands, despite the color of the socks.
Please join me in thanking the Chief Justice and all of our guests today. Just before you go, let me say just a couple of brief thank yous. I'd like to again thank Guy Pratt and Mary Pratt for their support of this program and for leading it forward and for the sensational casting and for convincing all these very busy people to give their time. I want to thank Borden, Ladner, and Gervais for their support of today's event. I'd like to thank, once again, all the lawyers, all the judges who took part. I'd like to thank Bonna Duncan, our stage manager, and the fabulous Stratford Festival Company for what they did of a Saturday morning. And I'd like to thank Kelly and Michael Meehan. This is a couple that have supported the festival for so many years, and when I went to them with the entire idea of the forum, they jumped on it right away and said, we'd love to support that. And so, Kelly and Michael, thank you so much for this. Thank you, all of you. Yes, please. The Stratford Festival season is wrapping up in a number of weeks, which means two things. One, you can still see so many great performances. And two, you don't want to delay. I want to thank you so much for your support. Have a great day. Thank you.